Okay, I can see that filling up, so I think we'll make a start. As I said, good morning everyone. Thank you very much for joining us today. I would like to welcome you to our webinar this morning where we're going to be talking about employment issues. My name is Chrissy Scott. I'm a partner and head of education at Harrison Clark Rickabees. When we decided to hold this webinar a couple of weeks ago, partly with the wider opening of schools in mind, but we were much more guided by what was coming across our desks. And that's really become the focus of what we're going to talk about today. And like you, we are still waist or neck deep in government guidance. And I'm really hoping today that we can answer your questions. I'm delighted today that I'm going to be joined by my colleagues, Rachel Parkin and Oliver Daniels. I'm going to start off with a look at furlough changes. Then I'm going to hand over to Rachel, who will look at cost-saving measures regarding staff and how you can do that in a number of areas. Oliver's then going to look at changing terms and conditions of employment as well as redundancies. Quite a lot to get through, but we hope to have time for questions at the end, and some of you have been kind enough to submit questions in advance. You know what to do here, so please use the Q&A function on the bottom there as opposed to the chat for any questions that you may have. So without further ado, let's start with the first slide by looking at furlough changes. So furlough, new word for us all, new term, which we're all fairly familiar with now, announced at the end of March, and we've had various iterations of guidance for employer and employee. It's one of a number of central measures that was put in place by the government, and it has changed over time. You may recall that when it was first mentioned and talked about, it was actually a way of avoiding redundancies. And over time, that disappeared pretty quickly, and now it's much more of an income protection scheme. So my understanding is the idea behind it is to protect jobs, to keep people employed. So the government help is there to keep those jobs open. In terms of the scheme itself, currently the requirement is that the employee must stop working for that employer. That continues under the new changes, which I'll talk about in a moment. So by that, the employee must not do anything that generates work, fees, income for the school. So you can get them involved in training. So if you're holding training days or even team meetings, we find it's a great way of keeping in touch with your staff. So get them to come along to team meetings or trainings if they want to do so as a way of keeping in touch. Right, I'm now going to move to the next slide. We've produced various guidance notes. I hope you're not feeling too inundated about that, on the changes as they've taken place, including the fairly controversial issue of furloughing teachers over the summer holiday period. I'm going to touch on that at the end, that and term time only staff. And on Friday the 29th of May, there are a number of key changes announced by the government, which effectively says that from the 1st of July, not too far away, that all employers, including schools, have more flexibility over the arrangements that you put in place. And you can bring back employees for any amount of time and any working pattern, whilst you're still able to claim the grant for the hours not worked. So this gives total flexibility to the school, to the employer. And my understanding is that the main aim of these changes is to support employers with bringing staff back to work on a way in which that suits them. And I'll talk a little bit more about flexibility in a moment. We talked in our note, which we sent out, I think it was about the 1st of June, after the changes were announced on the 29th, about the 10th of June, which was last week. The 10th of June was the cut-off date for getting that 3-week period of furlough in. You might remember under the scheme from March to the end of June, a member of staff had to be furloughed for a minimum of 3 weeks. That means that if you have not furloughed a particular member of staff at the moment, or they've not been on a period of furlough on or before the 10th of June, you will not be able now to furlough that member of staff, as the scheme is now closed to new entrants. That's from the 30th of June, but if you count back the 3 weeks, I hope that makes sense. One of the points that has been clarified by the guidance which was issued on the 12th of June, and I have to say that we were all watching out for that because we knew it was the 12th, and it was about 9 o'clock at night or 1 o'clock at night when that came out, which confirmed actually that you do not currently have to be on furlough in order to access furlough after the 1st July. So you could have staff that were furloughed in May that could then be furloughed after the 1st of July. So long as they're in the system, you'll be all right. One of the most important points I think to remember is thinking about how the scheme grant works from the 1st of July to the end of October. And there was a very small paragraph on this, which was almost buried in the announcement on the 29th of May. And it's this question of a numerical cap. And there's a bit more detail of that in the announcement on the 12th of June. So the numerical cap means that the number of employees that a school can claim for in any one claim period cannot exceed the maximum number it has claimed for under any previous claim during the March to June operation of the scheme. So if, like many schools, you've been rotating employees, you need to be mindful of this cap. So I know a number of schools, for example, might have, let's say they have been open to key worker children, and they have had, I don't know, a chef in or a cleaner in, but they've decided to rotate that between, let's say, 2 chefs. So they've rotated the period of furlough. So the example given in the guidance of the 12th of June is that if in respect of each respective claim period, your claim was 30 employees, 20 employees and 50 employees in 3 separate periods, then the maximum number of employees you as a school could furlough in any single claim after the 1st of July is 50, because that was your maximum number. So even though you might have in total furloughed, let's say 80 employees or 90, you can only claim for that maximum in any one period. Now, of course, you can still rotate those staff, but that's just something to be aware of. For June and July, the scheme grant as we know it, stays as it is. And the first time you can make claims for July is from the 1st of July. And the 31st of July, the end of that month, is the last day you can submit claims for the periods ending on or before the 30th of June. So you've got that month in order to get your claims in for up to June. Okay, if we just move to the next slide, please. I'm going to fly over this because you've probably seen this hopefully on our notes. So this is just setting out the changes. So effectively, from the 1st of August until the end of October, changes taking place on the 1st of each month, the amount of the grant over time will diminish, or the employer's contribution will increase. So from the 1st of August, the employer is required to pay NIC and pension, and so on and so forth. So the 1st of October, the grant will be 60% instead of 80%, and there's going to be a wage contribution as well. I hope that's fairly clear. Next slide, please. My final slide. I'm going to look at flexible furlough. So this sounds great, doesn't it? Although you have to think about how you're going to track it. So flexible furlough, as I mentioned at the outset, is this way of bringing back employees for any amount of time and any work pattern, dependent upon the needs of the school. And you've got a caveat that if it is safe to do so. So any number of employees for any amount of time from furlough, if it's safe to do so. So that goes back to the risk assessment that I know you all have all been doing in terms of how many staff you can have on site, comply with any protective measures, guidance, etc. So you can change your plans week by week. So you don't have to have the 3-week period for furlough any longer. So that will go. Excuse me. You must ensure that you keep a record of that, as you may be audited, as you probably already know, by HMRC, and those records have to be kept for a period of 5 years. Legislation has been taken through quickly, as you've probably seen that this week, to set out what HMRC can do in that regard. One of the important points is that you need to confirm what has been agreed with the employee in writing, and there should be written agreement, possibly just a letter to that effect. We are currently drafting 2 letters for the ISBA, which might be helpful for you. So standard letters that will go on the reference library. One is an extension to furlough letter, and one is a flexible furlough letter. So those should be available fairly shortly. If and during the time that the employee is on furlough, the same rules about not carrying out any work for the schools still apply. They can still do training, etc. But any time that they're working, they must receive their normal wage for the hours work. So as a school, you've got to think about the best way, the easiest way for you to administer this and track staff. It might be something you don't use as much over August if you're closed, but obviously from September and also for October, it might still be a system, depending on where we are with school opening at that time. So before I hand over to Rachel, I just wanted to touch on a couple of common questions that we've had. One of those is about term time only staff being furloughed over the summer holiday period. And you might have seen our note on that said, as a general rule, we wouldn't advise that, because the furlough is meant to cover a period for when the employee is required to be at work. And generally speaking, a term time only contract is fairly specific on that point. However, having said that, if you furloughed term time only staff and actually they've been off, let's say, since April, you're just extending that, probably less risky. What probably wouldn't be in the spirit of the guidance is having them working for the school during term time and then being furloughed for the school holiday period. So I hope that helps. As I said, please put any questions in the Q&A box and we will try and answer them. Now, I'm now going to turn to cost-saving measures. I'm delighted now to be joined by my colleague and partner, Rachel Parkin. You've probably already seen Rachel on our previous webinars. She is immersed in the sector. She spends all of her time advising schools on employment issues. So over to you, Rach.
Thanks, Chrissy. Inevitably, COVID-19 has forced schools to reassess staffing requirements and consider potential cost-saving measures. Oliver and I are going to spend the next half an hour looking at some of the options available to you, with a particular focus on restructuring and redundancies. As I'm sure you can appreciate, we're not going to be able to cover absolutely everything within a half hour. I think half hour, we've still got half-hour session, but we will try and highlight the key issues which schools will need to think about when you're looking at implementing any of the options. We are, as Christine says, happy to take questions at the end, and of course you can contact us subsequently. Of course, for many schools at the moment, the challenge is getting staff back to work and ensuring that you've got sufficient staffing given the likelihood of higher absence levels, where staff are unable to work, perhaps because they're shielding or perhaps because they've got parent responsibilities. And so redundancies may not be at the forefront of your mind at the moment. It may therefore be necessary to look at some other options in terms of cost savings without reducing headcount. So as Chrissy has already said, until the end of October, you can of course take advantage of the job retention scheme. Of course, the government has clarified that you're going to have to contribute or make a financial contribution towards furloughed employees' pay from the 1st of August. So furloughing employees beyond that date will obviously come at a cost to the school. If you have work for staff, but not necessarily at the level of before COVID-19, you might want to think about asking staff to reduce their working hours. So either on a temporary or perhaps permanent basis, and consequently reduce pay. When you're looking at adopting shorter working hours, I would advise that you are clear about the reasons for the reduction in the hours, and you're able to explain to those employees the financial impacts of those cuts, both on them individually, but also in terms of, individually in terms of their salary and any reduction in benefits, but also on the school as a whole. So where jobs might be saved if they adopt, or if these measures are adopted. If you do intend to talk to staff about reducing hours and or pay while still taking advantage of the job retention scheme, you're going to have to think about those employees who've agreed to continue working for less, while some of their colleagues are perhaps on furlough, receiving a similar amount of pay, but not doing very much. If looking at reduction on a temporary basis, you'll also need to think about whether the school is able to require those employees to come back full time if the work levels do pick up. So you just need to think about those sorts of things when you're looking at reducing hours. Of course, you could consider a reduction in salary without reducing hours. If you're thinking about doing that, then communication and obviously negotiation with employees or trade unions are going to be key. Short of job losses, this is probably the most controversial, as I'm sure some of you have found if you've already embarked on the exercise, a controversial practice that you might adopt. But if you are looking at reducing remuneration, it's advisable that staff understand the cost benefit elements of the exercise. And if possible, senior management should lead by example by sharing in those cuts. Ideally, measures could be limited in time with perhaps a long-term promise that once market conditions change, then the pay might improve. You need to think about employee motivation and commitment to the school, because inevitably that could be affected with a pay cut. But if you explain clearly why you're seeking to adopt the option and the overall positive impact that you're trying to achieve for the school, then hopefully you're more likely to secure their consent. Salary freeze is of course another option you may want to explore, and it could be a lot easier to implement unless employees of course have a contractual right to a pay increase, either expressly or through custom and practice. Most employment contracts provide for salaries to be reviewed perhaps annually or periodically, but less contracts give a contractual right or express contractual right to an annual periodic increase in pay. So I think the ISBA model contracts refer to salary being reviewed annually, but with no obligation to award an increase. To the extent that contracts only promise a review, then, and there is no risk that any increase is contractual, then it could be permissible for you to freeze pay once you've carried out the review. Commercially speaking, although such a step is unlikely to amount to a breach of contract, a salary freeze is often viewed by employees as, in real terms, a pay cut. So it could, as I've said before, reduce motivation and morale. So you should clearly communicate the reasons why you're doing it. And again, leadership from the top is highly advisable. Of course, a pay freeze on its own might not be enough to avoid redundancies, so you might have to look at implementing other options alongside the pay freeze. Another option to consider is unpaid leave, and agreeing on a period of unpaid leave with an employee on a temporary basis. This could be attractive to some people. So some employees who perhaps are struggling to get back to work because they've got caring responsibilities, or they're struggling to fully perform their role because of it, then they may well be quite keen to explore the opportunity and agree a period of unpaid leave. And a further option could be the redeployment of staff to busier areas of the school. To implement most of these cost savings, schools will ideally need to obtain the employee's consent to vary their terms and conditions to avoid the risk of any claims. But Oliver's going to look at this in more detail shortly. Inevitably, those schools are likely to have to consider redundancies or restructures at some stage, whether that's now or in the future, particularly if there is a severe recession, as is anticipated, and parents are unable to afford fees, resulting, of course, in a drop in pupil numbers. If redundancies are a consideration, you will need to consider the number of dismissals proposed and whether or not that triggers collective consultation requirements. So moving on to my next slide. In any potential redundancy situation, you will, of course, need to consult with employees. Whether or not there has been any collective consultation with the appropriate representatives, the obligation to consult with individual employees will always apply, and that's likely to prove central to the fairness of any individual dismissal. The duty to collectively consult arises where you're proposing to dismiss as redundant 20 or more employees at one establishment within a period of 90 days or less. For these purposes, dismissals are terminations of employment, of an employment contract, so it would include voluntary redundancies. Since April 2013, the proposed dismissal of employees on a fixed term contracts on the agreed termination date or on an agreed termination event don't necessarily need to be taken into account, but it does depend on the reason for the dismissal of the fixed term contract or the ending of the fixed term contract, and also the timing of that dismissal. I actually had a very interesting question yesterday where a client asked me whether an exit via a settlement agreement would count towards numbers. In terms of an answer to that one, if the employee concerned is one of those that you're looking to terminate by reason of redundancy as part of your proposal, they would count, regardless of how that termination is ultimately effected. But if the reason for the settlement agreement is not redundancy within the wider meaning, which I'll come on to shortly, then they wouldn't necessarily need to be counted in the numbers. So as I just mentioned, redundancy does have a wider meaning in the context of collective consultation, and it means a dismissal that doesn't relate to the individual employee concerned. So it does include the traditional concepts of redundancy under the Employment Rights Act, but it also includes dismissals for some other substantial reason. So cover situations where you're thinking about changing terms and conditions, for example, by way of a dismissal and re-engagement. Those of you who have embarked on a consultation regarding a withdrawal from the TPS will probably be quite familiar with this. Moving on to my next slide. The obligation on the school is to consult appropriate representatives of the affected employees. Now, affected employees are those who could be affected by the proposed dismissals or by measures taken in connection with the dismissals. So the term extends beyond those immediately at risk of dismissal to include those who would be affected by any measures associated with any redundancies. So the term measures is probably familiar to some of you in the context of a TUPE transfer, and helpfully in the context of collective redundancies, there is no further definition, as is the case in TUPE, but the term measures is likely to include any organisational step taken in connection with or as a result of the redundancies. So that could include things like new reporting lines because of redundant employees, or new systems of work, new working hours or arrangements, or anything like that. Where any of the affected employees fall into a category in respect of which a trade union is recognised, then the trade union must be consulted. Only where there is no recognised trade union in respect of the affected employees does the school have a choice as to whom to consult, and may choose to consult either representatives directly elected by the affected employees, or indeed an existing body of employee representatives. The employees have no right to choose. The decision is for the school. So in practice, we find that most employers will choose to consult with representatives directly elected by the affected employees, rather than a standing body of representatives. There are statutory rules governing the election of employee representatives specifically for the purposes of collective consultation. I don't have quite enough time to go into that today, but you'll find that in the legislation. Where the duty to collectively consult applies, you must also notify the Secretary of State for Business of the proposed redundancies on a form HR1, and actually a failure to do so is actually a criminal offence. Consultation must start in good time to allow the relevant discussions to take place. There are minimum timeframes that have to take place before the first of the dismissals take effect. Case law suggests that good time is not judged according to how much time has passed since you first contemplated or proposed the redundancies, but rather it's according to how much time is left until the proposed redundancy date. Where 100 or more are proposed, consultation must begin at least 45 days before the first dismissal takes effect. And for redundancies of between 20 and 100, the minimum period which must elapse is 30. Where it's necessary to elect employee reps, consultation can't begin, of course, until after those employee reps have been elected. And you'll need to provide certain statutory information to those employee reps. And the date on which that information is provided tends to be the date, or is the date, on which consultation begins. So that's the information such as things like the numbers and descriptions of employees, the proposed selection method, all of that sort of thing, and that's all set out in the legislation. A common misconception I find is that collective consultation must last for that minimum period. Well, in fact, the requirement is for the minimum period to lapse between the start of the consultation and the date the first dismissal takes effect, not to be necessarily the duration of the consultation. Obviously, in practice, many people ensure that the consultation lasts for the 30 or 45 days. In reality, it's all going to depend and vary on each case. Holding lots and lots of meetings will not necessarily guarantee adequate consultation. Equally, one single consultation meeting will not necessarily result in a finding of insufficient consultation. The obligation under the legislation is to consult with a view to reaching agreement. So the process has to be continued for as long as possible, or as long as is appropriate, in order to either reach agreement or exhaust the possibility of agreement. It's not obviously an open-ended process. We need to draw a line somewhere. So no matter what happens with the employee representatives and the suggestions that crop up, it's clear that you'll obviously want to cease consultation at some point and begin to implement your redundancy proposals. Employers frequently find themselves making redundancy proposals in successive batches. And a question I've been asked, I think about 3 times this week already, is what happens if, for example, you initially propose 10 redundancies and then needing to make further job reductions down the line, want to propose a further 10. The original proposal would not of itself trigger the obligation to collectively consult, but if the second batch of 10 redundancies have been proposed in the same 90-day period, which is a rolling period, then the duty to collectively consult is arguably triggered. Now, this could cause problems for you if you've already begun to implement the first batch of redundancies, especially if you've already issued notices of dismissal. Interestingly, there's actually only one reported case on this point, and that dates back to something like 1978, I think. And in that case, an employment tribunal held that the law doesn't retrospectively impose the obligation to consult in respect of dismissals that have already happened, merely because further redundancy proposals emerge. It's only a first instance decision, it's not binding, that means, so be interesting to see what happens with future decisions. The case there concerned a situation in which the first batch of dismissals had already been put into effect, and therefore they were no longer proposals, but sort of a done deal, really. Where the first batch is still only a proposal, I would say that there probably would be a strong argument to say that they should be consulted with if the second batch takes you over the 20 threshold. Of course, there's also a risk that a tribunal may think you've deliberately separated the redundancies into batches to try and avoid the collective consultation obligations, but hopefully that won't be the case. If you are near the threshold, and I know I've had a few clients that have done this, you may want to just collectively consult or consider collectively consulting anyway to minimise any risks in this regard. Special rules apply where the earlier batch of proposed redundancies are already the subject of collective consultation and then a further batch is proposed. You don't necessarily need to collectively consult on the second batch, but that's all in the legislation. So moving on to the next slide, an effective consultation process. Well, the classic case law definition of a fair consultation was provided in a case back in, I think, 94. And it clarified that firstly, consultation should be when proposals are still at a formative stage. So that's before any decisions have been made, which is why we're always saying, make sure you say to your employees, it's just a proposal, it's just a proposal, and talk to your employees on that basis. Adequate information needs to be provided on which to respond. They need to be given time to respond, adequate time to respond. You need to have you need to consider all their responses genuinely and think about what they've said and enter the consultation with an open mind and with a willingness to be persuaded. Although, as I've mentioned, you are supposed to conduct consultation with a view to reaching agreement, that of course doesn't require you to agree to any counter proposals made by the employee representatives. Whenever employees' views are rejected, I'd recommend that you document that and explain obviously to them why you are unable to accommodate their requests. Equally, where views are taken on board and are help to improve or indeed change the proposal, then due credit and recognition should be given and documented. And finally, is it possible for a school to conduct a legally compliant consultation exercise in the current circumstances? It's a question I've been asked a few times, and the short answer is yes. Clearly, there will be a lot more things for you to think about at the moment. Coronavirus has created a situation where we have many employees either working at school, on furlough, working from home, self-isolating, which makes collective consultation a bit of a challenge, but it can be done. In terms of additional issues that you'll need to think about, you may want to think about having an initial meeting with representatives to discuss the remote consultation process and how it's going to work, you'll need to make sure that all the representatives have the technology required to participate, and you might want to think about agreeing some guidelines in advance about how meetings will be run. So for example, if meetings will be recorded, that's one thing that you might want to discuss. Helpfully, there's no requirement in the legislation for face-to-face meetings, and so virtual meetings will be sufficient. Potentially, some meetings could now, of course, be held in person, with some people now back at school. So you'll have to think about the appropriate risk assessments, protective measures, and obviously make sure that you're acting in accordance with the current government guidance. If a ballot is required, then this must be in secret, but it's not necessary to have a ballot box with physical attendance to drop a ballot paper in. You can make arrangements for ballots to be held online. Another couple of questions, just finally, I've been asked a few times recently, is whether an employee can be subject to redundancy consultation whilst on furlough, and also can employees on furlough be employee representatives? Well, again, the short answer to both questions is yes. The employer guidance on the job retention scheme provides that union representatives, whether official or elected, are able to carry out representative duties without rendering themselves ineligible for the scheme. And similarly, ACAS have actually said that individuals can participate in their own disciplinary and grievance hearings without being taken out of the scheme. So on that basis, we're of the view that employees can participate in their own redundancy consultation exercise. Otherwise, you would in effect be unable to make redundancies whilst employees are covered by the scheme. And we know that's not the case because the employee guidance makes clear that it is possible. Whilst you're not required to wait until the scheme ends in October before making redundancies, if you do decide to proceed with doing so over the next few months, I would suggest that you document your reasons as to why it's not suitable to continue furloughing any individual that is on furlough at the moment in the particular circumstances. Where you've got a genuine redundancy situation, the option to furlough employees will not mean that a dismissal will be unfair, but it could be a relevant factor in determining fairness. So you just need to think about your reasons why furlough is not an option, and you need to embark on the redundancy exercise. Of course, from August, furloughing employees are going to will come at a cost for the school anyway. So this is going to assist in your justifications in this regard. Oliver.
Thank you and good morning, everyone. I'm going to look in a bit more detail now at some of the key issues we come across in advising schools on either changing an employee's terms and conditions or implementing redundancies. And I'm going to start with changing terms and conditions. The first step, wherever you're proposing a change that impacts on your staff, is to ask the question as to whether that change amounts to a change in that employee's contractual terms of employment. Sometimes that will be very straightforward. Clearly, if you're dealing with a proposed reduction in salary, a change in working hours, the fundamental terms of the contract, they will always amount to contractual changes. But it won't necessarily always be that straightforward, and it's really important before you embark on a process with your staff to be clear on what contractual terms you have in place with those who are affected. The first step will always be to look at the express terms of the written contract of employment, but it's also important to be aware that contractual terms can arise either verbally and also via an established custom and practice. If an arrangement has been in place for a number of years, is sufficiently well known and notorious within the school, it could by implication become a contractual term. So when you're considering making a change to potentially staff terms and conditions, you need to be thinking about what are the contractual terms and is that a contractual change or not. A good example of where the lines can be blurred in that respect is with pay freezes. So a pay freeze may or may not be a contractual change depending on what the contract says and what arrangements have been in place historically in relation to pay reviews. So that's a good example of where you need to understand what the contractual position is. And the distinction is important because in order to implement a contractual change lawfully and effectively, technically you need the agreement of the affected employees. And that inevitably necessitates having a clear and justifiable business case for making the change. And as Rachel has just covered, going through that genuine period of formal consultation with a view to reaching that agreement. Okay, just moving on to the next slide. So assuming what you're proposing amounts to a contractual change, what happens if after you've consulted with the affected staff, you have an employee who refuses to agree, or a group of employees who are objecting? What are your options in dealing with those objectors? Ultimately, your options are fairly limited in that scenario, and each carry a fair degree of risk. So you need to consider at the outset where you would go, what approach you would take when you're dealing with potential objectors. One option is that you could look to unilaterally enforce the change without that member of staff's agreement. The risk clearly there is that that would amount to a breach of contract. And depending on the nature of the change and the significance of that breach, you'd have a risk of breach of contract claims. And if the change is really fundamental in terms of the contractual relationship, you could have a risk of the objecting employees resigning and pursuing claims of constructive dismissal. In that scenario, you could also have the risk of an employee who objects continuing to work for the school, but under protest, in order to reserve their right to potentially bring a breach of contract claim at a later date. And that can present a particularly risky scenario where you're dealing, for example, with reductions in salary, where there'll be that ongoing loss for the employee in question. Due to those risks, it's often seen to be legally cleaner to instead dismiss an objecting member of staff and offer them immediate re-engagement on the revised terms. But clearly that's, again, a pretty drastic step to take, and inevitably there'll be risks involved, not least the risk of unfair dismissal claims. So practically what you're doing there is you are dismissing the employee on notice and at the same time offering them re-engagement on the same terms and conditions, save for the change that you are looking to implement. And if the employee doesn't accept that offer of re-engagement, then they are dismissed in law. Another factor you need to take into account in respect of dismissal and re-engagement is that that dismissal will be on notice. So you will have to cover the cost of notice pay. And depending on what you're trying to achieve, particularly if you're looking to implement a temporary reduction in pay, which many schools may be looking at the moment, it might negate actually what you're trying to achieve and the savings you're looking to make. In respect of both of those options, clearly the number of objectors that you have will be relevant in deciding the approach that you take. The higher the number of objectors, the higher the risk. And you need to be thinking about that in determining the approach that you take in dealing with any objectors. One question that does come up fairly regularly is whether it's possible to make concessions for certain objecting members of staff based on specific individual circumstances. For example, in respect of a pay cut, you might find that there are certain staff, due to their personal circumstances, who are affected to a greater degree than others. Particularly from a pensions perspective, you might have staff who are members of the TPS, who perhaps benefit from a final salary element of that and are close to retirement, and a reduction in salary would impact them particularly adversely. In principle, it is possible to make concessions on an individual case-by-case basis, but clearly it's by no means an ideal scenario. You have inevitably the employee relations risks of that becoming known amongst the other staff and that creating concern. But you also inevitably also have the risk of allegations of discrimination arising where you apply that discretion. So it is an option that could be considered, particularly given the risks of unilaterally enforcing the change or dismissal and re-engagement, but it needs to be thought through on a case-by-case basis, and you need to have a clear internal justification for making any exception. I think the risks associated with all of those options just really emphasise how important it is to ideally reach agreement with all staff, and if not all staff, the vast majority of staff who are affected, and the importance of having that clear business case and going through a fair process of consultation. Okay, just moving to the next slide. Of course, for many schools and employers, the current circumstances will mean that, unfortunately, there's a need to look at making staff redundancies. And I'm going to look now at some of the practical issues that we see in advising schools in implementing redundancies. One of the most significant being the question of actually whether what you're proposing amounts to a genuine redundancy situation in accordance with the legal definition. We have a legal definition of redundancy, which, leaving aside business closures, requires an employer to demonstrate that there's a diminished requirement for employees to do work of a particular kind. And again, that's not always clear-cut, particularly where you're proposing a reorganisation or restructure of duties and responsibilities that might result in the removal of a particular post, but a continued requirement for the duties and responsibilities associated with it. And those duties and responsibilities will continue to be performed, but in a more cost-effective way. It's unlikely that that type of reorganisation would fall within the category of a genuine redundancy situation, as you're not showing that there's that diminishing need for the type of work that's being carried out. And the courts have been clear that the focus should be on the requirements of the business, not individual employees. That question of whether it's a genuine redundancy or not is important, because in order to defend potential claims of unfair dismissal, you need to be able to point towards one of 5 potentially fair reasons for dismissal set out in law, one of which is redundancy. And you won't be able to benefit from the redundancy fair reason for dismissal if it doesn't fit within that definition. If it is that reorganisation as opposed to a genuine redundancy situation, it may well be that a dismissal is still justifiable and still fair, but not necessarily on the grounds of it being a redundancy, but rather a separate category of fair reason known as some other substantial reason, which is effectively a catch-all reason which employers can use if the reason for dismissal doesn't fit neatly within some of the other fair reasons set out in law. Employment tribunals generally don't like employers using some other substantial reason for dismissal, but if you have got a genuine restructure, there's a business case for it, and you've been through a fair process, that can be used to establish a fair dismissal. But it's important to consider that question at an early stage because it will impact on the process that you follow and the potential risks. Okay, just moving to the next slide. Working on the basis of a genuine redundancy situation, you have a number of additional obligations that you need to think about when implementing a fair dismissal. One of which is thinking carefully about what your selection pool is for redundancy purposes. In other words, who is potentially at risk from your proposals? Employers generally have a fairly wide discretion in determining the pool of employees at risk. But if it's deemed to be too narrow or too wide, that can impact on the fairness of your decision. When you're thinking about your selection pool, what you need to focus on is what work is diminishing within the school and which employees perform that work in order to come to a view as to what is a fair selection pool for redundancy purposes. And as part of that, you may need to consider the extent to which staff are doing similar work or skills are interchangeable. It is possible to have a selection pool of one and to deal with an individual discreetly as part of a redundancy process. And in that circumstance, you would just consult individually with that person. There wouldn't be a selection process as such, but you would consult over the proposed changes and the redundancy with that person individually. You need to be clear that that is justifiable, however, because those sorts of decisions can be subject to quite careful scrutiny in the event of a challenge. Where you do have that need to select staff to be made redundant from within a pool, you also need to think carefully about how you're going to achieve that selection and what selection criteria you're going to use to identify the individual who will be made redundant. That's going to be based on what the school ultimately needs from a business perspective going forward. And ideally, the criteria that you will use will be as objective as possible, will be measurable, and you'll be able to point towards evidence to justify the scoring that you are applying to the staff who are potentially affected. So you might have things like disciplinary record, attendance, performance, timekeeping, skills and qualifications as being objective selection criteria that you might use. What you need to be conscious of in terms of implementing selection criteria is that you're not including any criteria that could be seen as discriminatory. So you need to factor out, for example, disability-related leave or family-related leave. You also have a duty in a redundancy situation to look for suitable alternative vacancies within the school that may be an alternative for an employee at risk. A dismissal is likely to be unfair if the employer has given no consideration to that question. And that duty applies both during the consultation process and also during any period of notice that the employee works. So you need to keep that in mind as you're going through. What you're not obliged to do is to create a role where one doesn't exist, but there should be a thorough search of vacancies within the school, and you need to be able to document your thought process and the fact that you've done that so you can demonstrate that you're complying with that duty. And a redundancy is generally more likely to be considered fair if you've considered whether it's possible to avoid or reduce the need for dismissals. For example, by looking at the other cost-saving measures that we've been talking about as ways of mitigating and reducing the need for compulsory redundancies. And that could also include offering staff the opportunity to apply for voluntary redundancy, particularly if you're dealing with wide-scale redundancies and larger selection pools. You don't have to offer voluntary redundancy, that's not a legal requirement, but it can be helpful in certain circumstances to mitigate your risk, but also to demonstrate a fair process. Okay, next slide, please. So what are the risks of getting this wrong in respect of changing terms and conditions or implementing redundancies? Clearly, you've got the employee relations risks of losing staff goodwill, the risk of internal grievances if you're not seen to follow a fair process. And ultimately, you've got the risk of employment tribunal claims, in particular unfair dismissal claims, possibly constructive dismissal claims, protective awards if there's a failure to collectively consult where that obligation arises, and potentially discrimination claims as well. Just moving on to my last slide. In terms of mitigating those risks, the key point here, I think, is about preparation. The more preparation you can do before you actually engage staff in consultation, the better. And we appreciate that there will sometimes be commercial considerations which mean that time is of the essence, but the more you can do to prepare for that process, the better in terms of risk. So that's taking time to consider and document your business case, carefully planning the consultation with staff, thinking about your timeframes, but also building in some flexibility, because you never quite know what's going to come up as part of a consultation process. I think undertaking some due diligence in advance as to what the contracts say. If you're dealing with a change in contractual terms, are there any ad hoc custom and practice arrangements we need to be aware of? And who's affected by your proposals, particularly in the context of a redundancy situation? What is that selection pool? And as Rachel mentioned earlier, the mindset that you go into a consultation with is really important. Going into it with that open mind, genuinely considering and responding to the comments and feedback that you receive from staff. And ultimately, this is all about effective communication. No member of staff is going to be particularly happy to hear that they're at risk of redundancy or they might be having a pay cut. But it's about that hearts and minds approach and trying to get staff at least on board with the principles behind what the school is looking to propose. Well, that's a whistle-stop tour of changing terms and conditions and redundancies. I'm now going to hand over back to Christine for a Q&A.
Thank you very much, Ollie and Rach, for a really quick fly through on some quite complicated subjects. So hopefully, by the miracle of technology, we're now a panel. Thank you very much for all your questions, which have been flying in. Ollie, we had one question, a couple of questions submitted in advance, which we've tried to answer. We had a question about salary increases, and you might remember back in January, the increase to teachers' salaries was announced to take effect this September. And the question was whether it was legal to pay below the state sector if the state sector are giving a pay rise and the school doesn't. Have you got a view on that, Ollie?
Yeah, I think this comes back to the points we were making earlier around pay freezes. I think many schools will be considering implementing pay freezes from September. And as I said before, the question that schools will need to ask is whether a pay freeze amounts to a contractual change or not. If it doesn't amount to a contractual change, then arguably you can enforce that and you don't require the agreement of staff. If it does amount to a contractual change and you enforce that unilaterally, then you have a risk that that is then a breach of contract and is unlawful. So the key thing that schools need to be thinking about in considering a pay freeze is what does the contract say? And as I mentioned earlier, that's not just about looking at the express terms of the written contract, it's about looking at what the custom and practice has been as well. I think Rachel mentioned earlier that the ISBA template contracts refer to pay reviews and make it clear that pay reviews are at the discretion of the governors, that there's no obligation. So if that's the case, I think generally speaking, you can take a more robust stance. But what I would say is, as we all know with schools, you will quite likely have a number of different staff who are on a number of different contracts. Some
Yes.
quite historic contracts that will look very different from the new contracts that you'll be putting in place now. So I think it's about doing that due diligence and looking at what terms you have in place with your staff before you make that decision as to whether it's a contractual change or not. And that ultimately will vary on a case-by-case basis.
Thanks very much, Ollie. Really helpful. Rach, one for you here. When should the HR1 form be sent to the Secretary of State?
Well, yeah, that's an interesting question and one we get all the time. Well, the minimum periods that you're used to. So when you're looking at between 20 and 99 redundancies, then you'll need to send it at least 30 days before the first dismissal. If you're looking at more than 100, then it's 45 days.
Thank you, Rach. I've got a question from Elaine Oliver, who's asked about maximum cap, and I should have actually mentioned this in the furlough bit. So Elaine says, does the maximum cap include those currently on maternity leave who can be added after the 30th of June deadline? I should have said, for those individuals who are on mat leave or statutory leave, they don't have to have been furloughed before the 10th of June, providing they're on the payroll at the previous RTI date. So you can then add them in. The maximum cap would still apply though, so you don't get an additional number. So my understanding is that cap would still apply despite that. Okay, lots of questions here. A question I think for you, Rach. This one was about the waiting period. So if, for example, you make somebody redundant, a role is made redundant. 6 months later, you need the role again. Are they obliged to offer the role to the redundant employee?
No, is the answer to that question. You're not obliged to offer the role to the redundant employee, but obviously there's nothing stopping you if you want to make contact with them. By that time, the time limit for unfair dismissal claims would have passed, so you're not going to get that person going, hang on a minute, you said I was redundant and now you're asking me to come back and my role's no longer redundant. Yeah. But by that point, that deadline would have passed. So there's no obligation, but you can do so if you want to.
Thanks, Rach. Another one on redundancy, actually. If we are making more than 20 staff redundant, but across a number of areas across the school, some starting in July, some in September, do you need to elect representatives if the redundancies are sporadic? I'm presuming yes?
Oh, you're looking at me? Yes, sorry,
yes.
Yes, you do, yes, yeah. If you're more than 20 within a 90-day period, and that period is rolling, a rolling period. So there would be, in that example, more than 20 in 90 days. So you would need to collectively consult.
Yeah, and that's the bit you were talking about, wasn't it, in your part about it's quite often difficult at the beginning sometimes to predict how many staff over time you might need to bring into that number, so you can tot up, can't it? That can cause difficulties.
It can, and as I say, there's actually only one recorded case on it, which is kind of unhelpful, really, because this crops quite a lot. But you know, if you're at a point where at this point in time you don't know what it's going to look like in the future, you think you might have more redundancies but you don't know, then clearly it's going to be difficult to collectively consult on the future redundancies if you're not really sure how many that's going to look like or what. So if they're genuine batches, genuine groups, then that's going to help you if you haven't collectively consulted on the first batch. But yeah, if you can do, if you're looking at more than 20 and it's very, very likely and you've got enough information to do it at the beginning, then you should really collectively consult from the outset.
Yeah, and I suppose it goes back to the evidence, doesn't it, that you have in relation to what you've done.
Yes.
Record keeping. We love a paper trail.
Yeah.
Yes, there's a question here about furlough. So we've been asked, if an employer wants to bring back a member of staff on a flexible basis from the 1st July, if that, can an employee simply swap from current furlough to flexible furlough after the 1st July? Is there a waiting period? So swapping from fixed, current furlough to flexible? No, there is no waiting period at all. So they can simply switch from one to the other. The key point, and I mentioned this, and in fact someone's asked a question during my bit, is that you have to ensure that you've got the agreement to that. So you might remember with furlough, the employer designates, but the individual has to agree. So that's the important point, really. So you just agree on what basis they're going to be coming back. Ollie, I think this might be one for you. Talking about the difference between a voluntary salary reduction where somebody agrees to take a pay cut and an imposed pay cut in terms of consultation and time frame. Quite a difference, isn't there, where you get agreement and where they don't agree?
Yeah, absolutely. I mean, if you've got agreement to the change, then that is an effective and valid contractual change. So in terms of consultation, you'll be engaging with staff in consultation over your proposals. If you reach agreement, then with all of the affected staff, then at that point you can bring your consultation to a close and you can implement the change. But of course, if you're not in that situation and you haven't got that agreement, then it's going to be a more protracted process. But it's all about getting that agreement ultimately if you are dealing with a contractual change. And staff, you may find, particularly in the current circumstances, understanding that there are risks in terms of potential redundancies, potential threats to the future of schools. I think you may well get that goodwill from staff who are actually very willing to agree to a pay freeze or a temporary pay cut. And if that's the case, if that can be agreed and documented, then that's absolutely fine.
Yeah, that's helpful. In fact, there's a related question to that, Ollie, which has come in, which is about a school wrote to their staff to say there'd be a pay freeze back in March, April. Their contracts allowed them to do that. they've just appointed some teachers to start in September on the new pay scale that incorporated the planned increase. That's quite difficult, isn't it? Where you've offered that job to somebody on a different, and I suppose you could write to the new member of staff and explain the error. Alternatively, if they've accepted the offer, I presume you'd have to give notice of that.
Yeah, it all depends where you are contractually with that offer and acceptance. If the offer's been made on that basis and accepted on that basis, then technically you would need to give notice to change that position. But you know, the risks ultimately are relatively low, given that person won't have an established length of service with the school. But yeah, it can become quite tricky where that contract is technically in place.
Another furlough question. If you've unfurloughed someone, I love this, all these new terms, unfurloughed someone, then put them back on furlough, do they still have to be furloughed for 3 weeks, or does this disappear on the 1st of July? Well, it disappears on the 1st of July, so that's when you get complete flexibility. You could still furlough them for 3 weeks or longer, but that's when that completely disappears. And someone else has asked that if you have a written agreement to furlough already, and this is where we've seen an agreement between the employee and the employer, and the employee then moves to a flexible arrangement, do you need to have a new written agreement saying that what the new arrangement is? My view is that you would, which is why we're doing that flexible letter. Would you agree with that, Rach, that you'd need the new agreement to
yes,
that arrangement?
Yeah, definitely. You need the new arrangement set out in writing and an agreement from the employee to that new arrangement.
Yes. I mean, because interestingly, on the BBC News this morning, HMRC has apparently received 3,000 reports already of furlough abuse, where the scheme apparently has been misused. So I can see the next session we might do is on employment tribunals, but I can see that being the importance of record keeping, isn't it, Rach, of making sure that you've got that in writing and it's clear what's been agreed going forward will be really important, won't it?
Yes, definitely.
Right, well, we've come to the end of our allotted time. If there are a couple of more questions there, we'll try and send those out afterwards, because we do want to respond to you all, because we're grateful for your questions. So from myself, from Rachel and Oliver, and all of us here at HCR, thank you very much, everyone, for your engagement and involvement today. It's great to have your questions. Although we can't see you, it's good to know that so many of your familiar faces are there. Our next webinar is actually tomorrow with the ISBA. We're doing a session on inspections and complaints, very different. As I said, we're considering one on employment tribunals as our next session, but any other topics you want us to cover, just get in touch. We really value your input. So thank you very much once again. If we can help at all, please get in touch. We wish that you all stay well, to those in your families and schools. The work you're doing is amazing, and we are very proud to be part of the sector. Thank you as ever for your support, and we'll see you next time. Goodbye.